All right. Good morning, everyone. How we doing? We awake? Yeah? I know the guy who stayed up all night for the merge is a little bit tired. So good morning, everyone, again. As Tobin said, my name is Cody Carbone, and I'm the Director of Policy at the Chamber. We're going to switch gears a little bit, and we're going to discuss an amicus brief. And I'm really delighted to be joined by Lilya Tessler, partner at Sidley Austin and counsel to the Chamber, who really led this effort in drafting this brief. And, Lily, before we dive into the subject matter, if you could just provide a little context on your practice and your clients and how you got involved in this space.
Great. Thank you, Cody, and thank you for the Chamber for having me here today. Can you guys hear me? Yeah.
Yeah, I'm good.
Is this good? Perfect.
There you go.
Thank you, everyone, for having me here today. So in terms of my background, I'm a financial technology lawyer, primarily focused on securities regulation, and for many years have been advising a broad range of market participants with respect to different types of digital asset products, whether it's blockchain technology companies that may have a native token and try to navigate the securities laws, or regulated financial institutions, custodians, broker-dealers trying to support various types of digital asset products in their business and offering them to retail, institutional market participants. So I've seen and helped and understand the concerns of a broad range of the market participants. And I think there are themes that have come out over the years from a lot of the work that I've done that carry through into this brief. And I've gotten involved for a number of years with the Chamber and have filed an amicus brief in a prior similar case as well, primarily because of understanding the current regulatory environment. The evolving regulatory environment is something I'm knee deep in and I'm advising clients on. So happy to be able to contribute to this effort.
That's great. And so let's take a step back a little bit. If you didn't know, there is ongoing litigation between the SEC and Ripple. I think everyone here is pretty comfortable with the facts of the case, but maybe we can discuss a little bit the state of play, where the case is right now and how we got here.
Mm-hmm. So the original complaint the SEC filed against Ripple was in December 2020. It's been almost 2 years since the complaint has been filed. Ripple's response to that complaint was submitted in January 2021. And since then, there's been a long, drawn-out discovery period, motions back and forth around discovery. It's a pretty extensive process in terms of discovery. And then just as of yesterday was the first day that both parties, both the SEC, as of Tuesday, September 13th, both parties filed motions for summary judgment with respect to the certain decisions that the judge needs to consider as a matter of law. And in terms of timing, as soon as a motion for summary judgment is filed, thereafter, an amicus brief can be filed with the court, or motion for leave, which is what we filed, which is a request with the court to allow them to submit the brief in order for them to consider what the proper state of play from a legal perspective should be in the case and a legal precedent. So the first day that we were able to file the brief was September 14th, which was yesterday morning, the day we filed.
So you highlighted that this has been a long, drawn-out process, over 2 years to get to this point, and we still don't have a final conclusion. You also mentioned that you worked on a previous brief for the Chamber in the Telegram case. Now, I took a look this morning, and the first action was filed in the Telegram case in October. The final conclusion was March of the next year. Much shorter time period. What is going on? What are the distinctions between that case and the Ripple case that has allowed it to drawn out this long?
So in the Telegram case, that was filed by the SEC as a TRO, a temporary injunction, and then a permanent injunction that the SEC was seeking, given the urgency of the SEC being concerned about certain digital assets being put on the market by Telegram. And so it was treated by the court on an expedited filing and time frame, which doesn't exist here in the SEC versus Ripple case. In the SEC versus Ripple case, it is the court looks to the traditional time frame because the assets, there's no sense of urgency since the certain assets that Ripple had have already been in the market for quite some time before the case was filed. And so the urgency of the TRO and the permanent injunction hearing put the Telegram case on a much faster timeline. It also forced us to draft our brief on a much faster timeline the last time around to make sure we were timely when each of the parties in that case filed their motions for summary judgment.
So now I want to turn to the brief itself. Let's dig into it. And I don't blame anyone if they haven't had a chance to read it yet. Just filed yesterday. And as Perianne mentioned at the outset, it's been a very, very busy week for crypto policy. This case is really about issuance, but the brief goes much further than that. Maybe you can expound on the rationale for writing the brief and what we hope to achieve.
So the brief includes many of the same themes, to the extent anyone in the audience has read the Telegram brief, many of the same themes really providing the court, as a friend of the court, what the legal precedent is through today, including the long-standing Howey test, the investment contract analysis, which many of the courts and even SEC look to in this area. So setting the legal standard as it exists as of now, many of the same themes we had in Telegram. And then building on that and reiterating to this court, similar to what we did in the Telegram brief, that the investment contract test in Howey applies to the offering, not to the subject of that investment contract. And often digital assets are distributed through an investment contract, whether exempt offering or otherwise, but the subject of that investment contract may have a different characterization. Then the brief discusses how there is no case law, there is no precedent as to what law applies to the subject of that investment contract, similar to what was set forth in the Telegram brief, and also what the judge in the Telegram decision said, that digital assets that reside on a blockchain are simply technology and code. The investment contract is formed with certain undertakings and promises and offerings that are made under an investment contract where that digital asset, under which that digital asset is offered. And so that same theme carries through and reminds this court again that there is no law that applies to the subject of that investment contract. And this case is primarily, it is exclusively about initial offerings, or whether or not Ripple had initial offering of unregistered securities. However, the brief does mention that to the extent the judge does go beyond initial offerings in its decision or consideration and discusses secondary trading, it again reminds the court that there is no law on what applies for secondary offerings of digital assets that might have previously been offered under an investment contract. So it's a clean slate for legislation for the SEC to provide guidance on secondary offerings of digital assets and what law applies in that context.
I'm looking at the brief right now, and I'm looking at that point you just mentioned. You know, when there are these questions of unsettled law, the brief encourages the court to defer to the legislature. And we highlight in the brief some of those pending bills the legislature has introduced this year that may be important to take a look at. Maybe you can take a deeper dive into some of those bills and why it's important for the court to defer to the legislature in helping answer some of these unsettled questions of law that are up in this case.
So it's not typical for a court to set precedent where there's no regulations or rules. And so the reason we cite to different bills is to show that there is no regulations currently that apply in some of these contexts. But we cite almost a number of different potential legislations. But one in particular I want to mention today is the Lummis-Gillibrand Financial Innovation Act as an example, which highlights the distinction between an investment contract and the digital asset that might be the subject of that investment contract, where in that proposed act, you can have under SEC disclosure regimes certain key customer protection disclosures for anyone that's buying into an asset through an investment contract or otherwise, while that same asset, the ancillary asset as it's described in that bill, can also trade as a commodity or other characterization that digital asset may have, depending on what it is. So that's one example to highlight to the judge that there really is no law, and if there was, we wouldn't be seeing these proposed acts being considered by the legislation currently.
The SEC talks a lot. As was mentioned in the last panel, Chairman Gary Gensler is up in front of the Senate Banking Committee today, and he often tells industry what he thinks they should do. After writing this brief, what do you think, if you had to give the advice to the SEC, what do you think are there some things that they could do to make it easier for issuers so we don't have another case like this?
I regularly speak with the SEC and bring clients to the SEC who want to come in and comply with the existing securities laws and the registration regimes that exist today. And I think this brief and just the current environment with respect to secondary transactions and digital assets is an opportunity for the SEC to allow for market participants to come in and register, as we're hearing from some of the public speeches from the SEC. But in order for them to come in and register, they need to have clarity on how they can register. What are they registering? Are they registering the investment contract? It's clear you can do an initial offering with an investment contract, and existing regulation exists. Can you come in and register an investment contract on the secondary? How do you do that? What disclosures apply for the secondary transactions of an investment contract? And also, what happens if an issuer or registrant comes in proactively to register for a retroactive potential enforcement action? I think it's going to be important for market participants to hear that in order to come in and register, there's some type of amnesty, no action relief, so they don't have to go out through a prolonged multi-year litigation with the SEC in order to be able to comply with this new regime. So I think it's having a framework on how someone come in and register, and then what happens to some of the retroactive relief that they need in this area.
As you stated, this case is really about initial offering and issuance, but the conclusion of this case and the holding will impact intermediaries, ATSs, exchanges. What happens to them following the conclusion of this case? What should they be looking for?
So I think the intermediaries often it's not essential that they're looking to see what happens in this case, because I think it's important to them to see what law applies to certain securities transactions that they may be supporting. But they have, especially securities exchanges, broker-dealers, alternative trading systems in this space, they want to come in and they want to support securities transactions with underlying digital assets. But they struggle with what assets are they supporting that are securities? What is that instrument? And a lot of the guidance today that they've received, whether it's there's no action relief for ATSs that came out in 2021, and custody guidance for a special purpose broker-dealer, all of that, which we cite in the brief, points to a definition of a digital asset security. But the question is, what is a digital asset security they can support? So when they have clarity, when some of these registrants come in and register with the SEC or rely on exemptions, and they know which assets are securities, and they can start supporting them on those platforms that are regulated by the SEC as well. On the other side, there's also custody issues and what assets, from a custody perspective, these market participants can support, and how they custody them is another issue, and in the current regulatory environment.
I promised you before this, I'm not going to ask you what you think is going to happen at the end of this case. I'm going to stick to that. But where do we go from here? What are the next steps? What should people be looking forward to in terms of developments from the court?
So we will, in terms of timeline, the motions for summary judgment were just filed. Next month, on October 18th, both parties will file oppositions to each other's motions for summary judgment, and then replies to those oppositions are due on November 15th. So there's multiple more months that we will see the parties going back and forth and providing their views. It'll be interesting to see what the judge and how the judge looks to some of those arguments, and also to our amicus brief. But what's interesting is in that same time frame, there could be proactive, and there probably should be proactive guidance from regulators. The SEC, for example, has been public about them wanting to put out more guidance in this area and not regulate by enforcement. It could be that there's proactive guidance, and it may be applicable in this case, and the judge may not even have to reach a decision on some of these critical issues if there's guidance from the SEC. If there's legislation that might pass, it may not be likely in such a short period of time, but maybe. So there could be things that happen outside of the case that impact the issues in the case and may make them moot. And if not, then we'll have to wait and see on how the judge decides some of these motions.
So it sounds like stay tuned. A lot to look forward to. Lily, thank you so much. Please take a look at our brief if you haven't had a chance yet, and we'll always update you more with more developments. So thank you, Lily.
Great,
thank you, everyone.